Thank you. We're going to start the second portion of the session, and Melanie Manchi will be speaking about preparation of net family property statements.
So now that everybody is refreshed and perky again, on to NFP statements. Picture yourself as a judge starting yet another family law trial and pulling out the husband's NFP and seeing that he is owed a whack of money by the wife, and then you have a look at the wife's NFP and it shows the opposite. Imagine the frustration of the judge as he or she sits down with the two NFPs and tries to go through them item by item to figure out where the differences are, how much they are worth, and how these differences arose. The best thing you can do when presenting your NFP statement is to help the judge. Put yourself in the judge's position and figure out what you can do to make it easier. So first of all, we all know that NFP statements need to be filed at 2 stages of the litigation, 7 days prior to pretrial or settlement conference, and 7 days prior to trial. And the rules that require that are 70.4 sub 10 of the Rules of Civil Procedure and Rule 13 sub 14 of the Family Law Rules. The first thing you do is focus on your client's NFP. Make sure it's accurate. Make sure it's consistent with your client's financial statement. Most of us use a program now like DivorceMate where the information merges from one document to another, but you have to remember to create a new NFP statement after you've created a new financial statement late in the game so that all the updated numbers are there. When you're looking at the opposing parties' numbers, don't just let your clerk take the numbers off the opposing party's financial statement. You need to go over them with your client to make sure that both of you agree that this is the best number available to you for the opposing party's interest in a business or confirmed value of our RSPs, etc. Don't sweat the small stuff in your NFP statement. We all know as lawyers, we hate furniture and 1997 vans and art worth less than $500 and jewelry and golf clubs and all that kind of stuff. If we hate it, imagine how the judge feels. You gotta do your utmost to get rid of that. If there's competent counsel on the other side, you should have no problem in resolving that kind of those kind of items in the usual fashion, such as if it's furniture that's at issue, get each client to make a list, merge the list, get every item either of them remembers being in the house prior to V-Day, even the items that have been removed by one spouse, and flip a coin for who goes first. Everybody pick one until the list is exhausted, and then you can leave it out of your NFP. Just usual contents of home divided in kind. That's the best thing you can do to help the judge in regard to little items like that. If there's an issue between the spouses about the value of the 97 van and is it $10,000 or $12,000, pick a red book or a black book value, or if the other side's being really stubborn, sit down with your client and say, let's look at the difference between their number and ours. Let's look at how much it's going to cost to prove our case one way or the other and try and split the difference, or sometimes even adopt the other side's number if it's not a big difference and it's going to be costly to prove otherwise. Don't end your NFP statement necessarily with what the equalization payment is. I think it's very helpful for judges for you to put some more notes on the bottom of the NFP or on a separate page at the back showing the final accounting between the parties. So for instance, if you have a case where the wife claims to be owed, you act for the husband and you claim that the wife owes you an equalization payment of $273,000, but you also say the parties have agreed that the husband will buy the wife's half interest in the matrimonial home for $73,000, then what you're really looking for is $200,000 plus a transfer of the home. Show that at the bottom so the judge understands it and can see the cash differences between what each party is looking for. Similarly, if there's a business and both parties' names are on the business and it's really the business that's operated by one party and both of them intend that to continue following the separation or divorce, make sure you note that the business is shown as 75% on the wife's side and 25% on the husband, if that's the way the shares are held, and then do your accounting at the end that one party intends to buy the other out at whatever number, so it reflects the bottom line of cash. Some people try to deal with that issue by making the NFP statement itself reflect the buyout position. I'm not sure that's as helpful to a judge as when you show what the actual legal ownership reads, because that might be the question the judge first addresses, and in the event a judgment is delivered, that's the way the judge has to really analyze things. So do your initial NFP showing legal title and values, and then show your accounting at the end of your NFP. Remember, again, you're trying to help the judge. Instead of just an NFP statement when you start your trial, consider bringing to the court an NFP brief, even at the time of pretrial. And the brief would consist of a few sections. Firstly, an index. Secondly, a summary of what issues are in dispute. And thirdly, a series of tabs with the most obvious evidence that will be produced in regard to each of the issues in dispute. So I've given you that in my materials in terms of the index page. And if you look to the sheet under tab 7 marked Summary of NFP Issues in Dispute, this is just my idea of how you best help the judge, who, remember, is looking at those two statements, one saying husband owes wife 75 grand and the other saying wife owes husband 100 grand. So identify which issue is in dispute. So we start with, say, the wife's pension. Each party has had the pension valued. Husband's value says it's $219, wife's value says it's $123. What's the rationale for those differences? We tell the judge it's a different pension valuator's approach. And what's the variance? $96,000. So you go down each item like that so the judge can see where you're going, and then at tab A, if the judge chooses to flip to it in your NFP brief, the judge would find your pension valuation and your opponent's pension valuation, or at least the executive summaries thereof. And I think it's very helpful to a judge to get a sense at the beginning of where the trial is going and what the issues are. Also at the pretrial stage, it's very helpful. At the end of the trial, it's quite possible that you might need to file a new NFP. Often during trials, we have evidence comes out that surprises us, such as the situation where your client's husband's parent advanced $50,000 to buy the house, and there's always an issue on separation regarding whether that advance is a gift or a loan. Well, if your client's husband or wife's parent comes to the trial and presents evidence along the line of, yes, in 1996 I gave $50,000 to my son or daughter, I also gave it to my other two children. It's documented in my bank book. Each of the other two children has paid it back in 1999 or 2000. The reason I did that was a meeting with my financial planner who said I could afford to loan it but not give the money right now. So that's what I did. If you have a stream of evidence like that that comes out, you're dead in the water in trying to claim that that's a gift. So do a new NFP statement. You don't even have to admit it, but you might want to do it, one version of it reflecting that kind of situation. So at the end of the trial, the judge can see what the effect of that change would be. Remember, you're trying to help the judge. In fact, at the end of the trial, you may need to present a number of different versions of your NFP statement. Many many of us choose in a case where husband and wife each have RRSPs to equalize the RRSPs by way of a rollover. And if that's true, it's always a good idea to do a second version of your NFP statement, taking out the RRSPs and just having a little schedule at the back showing husband's RRSP is 100,000, wife's is 50, husband rolls over RRSP or 25,000 from his to her RRSP, and that equalizes them. Another reason you might need more than one version of your NFP statement is when there's a dispute regarding valuation date. And sometimes the figures are quite different, especially in an era of roller coaster stock markets. So you may take the position that V-Day was May 15th, 2000 on behalf of your client, but it's a reality that the other party's taking the position that V-Day was August 15th. So it helps the judge if the judge can see that your NFP number 1, and I would make sure your headings are really clear. Wife's net family property statement number 1, showing valuation date of May 15th, 00. And then you can have a second one, wife's NFP statement number 2, showing husband's stated valuation date of August 15th. If you do that, mark the top of them very clearly. Remember again to put yourself in the position of the judge who's flooded with all this paper, and when he or she goes to review and consider things later on, you're sifting through all kinds of briefs and books and documents. The more clearly you mark it, the more likely it is that the judge is going to look at it and get the point you're trying to make. So highlight the top of it, which one it is, and if you're filing 3 different versions of your statement for various reasons, give them to the judge in the form of a brief with an index, and so the judge can clearly see at which tab is the one with the August 15th date. So if you spend the time to try and do the most accurate and the most clean NFP statement with as little small insignificant stuff in it as you can possibly get away with, and one that clearly identifies the most significant issues between the parties in regard to NFP, having resolved all the little ones, of course, you will have hopefully a judge who is less likely to be confused and cranky and more likely to be able to focus on what are the significant issues between the parties at the trial. You will help the judge, and that will help you get the best judgment possible for your client. Thank you.
Good afternoon. My name is James Herbert. I'm here to talk about pleadings. Why are pleadings important? I think mainly because pleadings give a first impression about your case. I suspect that on the morning of the trial or the night before the trial, the first thing that the court looks at or the judge looks at is your trial record, which of course contains your pleading. A good pleading leaves a good first impression, and of course vice versa. In family law, one of the things I notice is that pleadings tend to get stale. That is, that things change between the time you issue your pleading and the time of the trial. That can be 1 or 2 or sometimes more years between the 2 points. So a lot of things change. Incomes change, the situation of the children changes. And another thing that often happens in family law cases is that there are changes in counsel. So you may be the second or third lawyer on the file, and your predecessor lawyer may have had a completely different view of the case than you did, may have pleaded it differently than you did. So I'm suggesting that in every case, you consider at least the possibility of amending your pleading. I'm not saying that you amend in every case, I'm saying that you consider amending in every case. And in the material, there's a checklist that I've prepared of 9 points that I think you ought to consider in the several months leading up to the trial in deciding whether you should amend your pleading. The first point is really Have you sued everyone that you need to sue? The first thing we probably assume is that in family law cases, the two parties are the husband and wife or common law husband, what have you, but that's not always the case. Sometimes you have to sue other people. If you want someone to be bound by a judgment, you have to sue them. You have to name them as a party to the action. And just a couple of examples I could think of are where you're representing a payor who stands in the place of a parent. In that case, you probably would want to add the natural parent as a party so that the court can determine the respective obligations of your client, that is the parent standing in the place of the party, of the parent and the natural parent. Another example I can think of where you'd want to add an additional party is where you're alleging a fraudulent conveyance. Say you allege that your client's spouse has fraudulently conveyed a house to that person's parent. If that's your claim, then you better add the parent as a party. The second point is sort of the opposite of the first, which is there anyone that you should let out of the lawsuit? You don't want to drag someone through the courts if you don't have a strong claim against them. So in that example of where you've added the parent in your fraudulent conveyance lawsuit, you may have determined through the discovery process that you don't have a very strong claim. And if so, you'd want to discontinue your claim against that person. If you don't, then you're increasing your client's liability for costs. The third point is, have you made all the claims that you need to make? It sounds sort of too obvious to state, but it's quite easy actually to omit a claim. There's all kinds of pleadings that I've seen where people have omitted to claim costs or interest or even some more substantive relief, and you ought to just have a look at your pleading with that in mind. Have you made all the claims that you want to make? And then number 4 is sort of the opposite of that, which is, are there any claims that you should discontinue? You may have made a claim, say, for constructive trust, and you may have determined that you're not going to succeed on that point. And if so, you ought to consider discontinuing that claim. If you force someone to prepare for a claim, the other side to prepare for a claim that you think you're not going to win, then you're exposing your client to a higher cost award. The fifth point is, have you claimed enough support for your client? If you're claiming $4,000 a month in spousal support, but your claim is for $1,000 a month, then you've got a problem, and you're going to find the other side arguing that your ceiling amount is $1,000 a month. So just have a look at it and make sure that the number is still something that's acceptable to your client. Again, you may not have drafted this pleading, and the person who did may have had a completely different view of the amount of your client's entitlement. Those are the first 5 points on the list, and those are all sort of points which would encourage you to amend a pleading. But of course, there are countervailing factors in this, and that's number 6, which is, will an amendment of a pleading lead to a request for an adjournment? If you amend your pleading in a way as to open up new factual issues, issues which have not on which there's been no discovery, no documentary disclosure, then the other side is going to be in a strong position to ask for more disclosure, more examinations for discovery. In my view, a trial judge is unlikely to force someone onto trial where there's been a whole new claim added with a whole new set of facts and where there hasn't been any discovery. The same, of course, applies to adding a party. If you add a party a month before the trial, the first thing that you're going to get is an adjournment request. The new party is going to say, I want to see the documents and I want to have a discovery, and you can't force me onto trial a month after you add me to the claim. So you have to weigh, on the one hand, the benefits of amending your pleading versus the significant possibility of an adjournment request. In some cases, it may be better to go to trial with an imperfect pleading. Your client may have a desperate need to go to trial and to get it resolved one way or the other. And there may be other cases where your pleading is just so flawed and omits some fundamental aspect of your claim that you're better off to delay your case by 3 or 6 months than you are to forge ahead to trial. There's 3 more points I wanted to address, and they're sort of mundane points, but points that are easy to forget. If you're going to amend, give as much notice as possible. Don't tell the other side the day before the trial that you're going to amend. That won't look good, and you're unlikely to get a warm reception from the other side and from the judge if you do that. The 8th point is remember to seek leave under Rule 48.04. That, of course, applies to rules of civil procedure cases. Remember that if you set down the action for trial and then you want to bring a motion, you have to have leave of the court. You don't have the automatic right to bring a motion. In my experience, the courts are quite liberal in that. They almost always give you the leave and hear the motion on the merits, but you should at least advert to that in your material and in your argument. The last point is another slightly mundane one, which is the amended pleading in the trial record. If you filed your trial record and then you amend your pleading, don't assume that the amended pleading will be in the trial record, because it won't be. The court staff will not fix up your trial record for you. So if you don't file an amended trial record, then what's going to happen is you're going to get to court. The judge is going to come in the courtroom having read the old trial record with the old pleadings and knowing nothing about your new claims, and you'll have to explain that to the judge. I think those are my comments. Thank you.
I'll try and limit my mundane points to my paper. So I would have a look at tab 9, which my topic is offer to settle. My name is Bob Berman, incidentally. And in that paper, I've compared both the rules under the family law rules and the rules under the rules of civil procedure for those of you that are practicing in Toronto. So you can have a look at the rules. I won't cite the rules, they're there. But I will share with you some practical observation about offers to settle. If you're looking for a way to force the opposing lawyer to focus on your case, if you're interested, as you should be, in an early settlement, if you're interested in getting costs for your client, then I commend offers to settle to you. The ideal time to file an offer or serve an offer is following service of the claim or the application of the motion. At that point, I think you should be considering right away the prospects for settlement of all or even part of the claim. And you should be discussing this with the advantages of settlement with your client right away. And you should be gleaning from your client his or her wishes in terms of settlement right away. In so doing, you should consider and discuss the cost consequences, which I've outlined in the chart for you, and advise your clients of the benefits of making an offer to settle at an early stage. You should always remember to obtain written instructions when you are talking settlement with your client, and you should confirm his or her instructions to send the agreed upon offer in writing. Under the family law rules, the client is required, you'll recall, to sign the offer. I suggest that you consider having the client sign the offer even under the rules of civil procedure. At the very least, as a practical matter, I would suggest that you email your client or even voicemail. Get them to voicemail or email you their instructions. If you're discussing offers to settle without instructions, in other words, or terms of settlement without instructions, make sure you tell the opposing counsel that you don't have instructions yet. And as I said earlier, use the chart to explain the cost consequences. The client should particularly understand the cost consequences when you've been served with an offer to settle, that you're instructed to reject. Make sure that at that point in time, you discuss with your client the cost consequences of rejecting the offer. And then follow up with a letter or a fax to the client. Having said that early settlement is a good idea, too early a settlement before you can be a disadvantage, because you want to have a full grasp of the evidence before you consider settlement. Consider serving offers to settle when the legal fees and disbursements are likely to increase. So that would be around the close of pleadings. You should be looking at offers, considering them maybe before or just after discoveries, and certainly following the setting down the matter for trial. Another tip about offers to settle, consider making severable offers. In other words, an offer that can be accepted in whole or in part, so that custody, for example, might be settled while leaving the issues of spousal and equalization unresolved. There's no reason why you can't make a severable offer. Remember to keep track of your offers to settle made during the case, because written offers to settle which are not accepted can be taken into account by the court in exercising its cost discretion, even if they're subsequently withdrawn or expire or made less than 7 days before the hearing. You'll see from the chart, or you'll know from the rules, that it has to be made at least 7 days prior to the hearing. But even those offers can be considered. So keep track of all of your offers. By the same token, consider on a continuing basis whether an existing offer to settle should be withdrawn. You have to be thinking. You may have an offer out there that needs to be withdrawn, that you haven't been withdrawn, and you may be surprised by its acceptance. If so, remember that the withdrawal must be made in writing. Okay, a rejection or a counteroffer does not operate to withdraw an offer to settle. So you just can't reject it. It has to be done in writing. Finally, if a proceeding is settled, remember that it's incumbent upon you to inform the registrar that it has been settled and confirm that in writing. Although in practice, I can tell you that even when you do that, it may not result in having your action removed from the list. I've recently actually issued and filed a judgment, and then months later received a notice dismissing the action. So sometime the registrar misses the ball. My paper is at tab 9, and it's, as I said, it's a chart. It has the rules. It reviews the whys of offers to settle. I won't go over it, but it outlines in detail the cost consequences, and it gives you the rules. It outlines in chart form the how. I like charts because I can use them after the seminar. So there's the why, the how, and then it outlines when offers expire, how to accept, and even it refers you to the rules on how to enforce. There's also attached some precedents right out of the rules, as well as a precedent from my office that you can plagiarize. Thank you.
Good afternoon. My name is Francine Shurkin, and I'm here to talk to you about taking stock. So here you are. The settlement conference, or the pretrial date, is looming. You've exchanged your pleadings, you've exchanged your information, and unless this case settles shortly, you're on your way to trial. Depending on the jurisdiction and the court that you're in, the trial date may be a short time after your settlement conference or pretrial hearing. So what do? It's time to take stock. This is something that experience tells you you have to do well before trial. If I may, a trial is not like an exam. We've all written exams, and this is not something that you can wait until the night before and start then. There are many points that you have to look at and consider in advance and take stock of so that you'll be prepared for trial. And if I can continue with the school exam analogy, if you do this part well, it's like a school exam because you may be exempted from the exam. That is, this is a stage where you can consider settlement, and you may arrive at a fair and principled settlement if you've done your work well at this time. And still finally, and for the last time, comparing this to a school exam, it's also not a problem if you're going to be writing the final exam, which is often a good idea, because again, you're going to ace that exam, you're going to be prepared. So looking at the points that are raised in the paper in your material, I'm going to take a look at those points that you're going to take stock of before the settlement conference or the pretrial from 2 points of view. First, I'm going to look at it from a timing point of view, what you should consider from timing point of view, and secondly, the points that you might want to consider from the point of view of your strategy of your case. Dealing first with the timing issues, there are 6 timing issues that I've tried to identify and that are raised in the materials. You've heard about all of these points this morning. The first is expert reports. Did you serve yours well in advance? And if you've received an expert report, have you considered a responding report, and have you obtained and served that well in advance? There are timing rules. Some of them, especially in the new rules or the family law rules, are rather short, but as you heard from Nicole, it advances your case to get this done at an early stage. Number 2, the request to admit. That's a very important tool too, as you've just heard. It makes your trial more efficient and smoother, and it can save you a lot of evidentiary problems. Ask yourself, have I done a request to admit? And don't wait until, obviously, the 19th day, that's too late, but don't wait till the 21st day either. Do it as soon as you can. And very importantly, have you received a request to admit? And if so, have you answered it? Because you don't want to let that 20 days elapse when you'll be taken to admit the truth of the facts or the authenticity of the documents. The third thing is a notice to produce business records. If your client or one of your witnesses is going to be relying on documents produced in the ordinary course of business, you need to serve a notice to produce business records at least 10 days before the trial, so don't forget that one. Point number 4, get your documents in order. Now, there isn't a formal time limit for getting your documents in order, but this is, again, something that practice tells you should do well in advance. I find it a good practice to list all of the documents that I intend to rely on and all of the documents I think that the other side is going to rely on. I consider which of those documents are controversial, and I take them out of my list. I then send that list, which is like a document, to the other side, and I ask them to agree to that list. That way, I've got a joint pleadings book which can be used at the opening of your case in trial. And it saves a lot of time, and it also makes your trial run more efficiently. It's very helpful to the judge to have a documents book. It's very helpful to you when you're asking questions if you can point to documents in a documents book, and it makes it a lot easier for your witnesses, who are the most nervous people there, when they can find documents easily and they're in a book. It makes your trial run more smoothly. The fifth and somewhat related point is that this is a good time to update your client's financial statement and your net family property statement so that they are in final form. When you do this and you're going through the figures, you'll see where you still have some outstanding difficulties or where you may still need some outstanding documents or get some more witnesses. You'll also, at this time, it will remind you that you should ask your client for the most recent tax return. It may be some time since you've done one. Their most recent financial information, and if they have a business, the financial statements of their business. And number 6, make sure that all of the documents are on your affidavit of documents. Check your affidavit of documents. If you've left some off, you don't want to be embarrassed about that at trial, so do an updated affidavit of documents. These time limits mean something. They're telling you to prepare for trial and to take stock well in advance. If you don't, you may miss a time limit, your case may be prejudiced, and in certain cases there may be cost consequences. So now you've thought of the timing of it, and at the same time that you're doing that, you want to think of the strategy of how you're going to be doing your trial. Something that some lawyers do is they think of what all of the issues are, and then they make two lists. One list is going to have all of the matters that are in dispute, and your second list is going to have all of the issues that are no longer in dispute. They've been resolved or they're agreed upon. For your list where you've got items that are in dispute, you need to take stock of both your documents and your witnesses. Starting with your documents, consider for each issue that's in dispute, what documents do I need to prove my position on that issue? And then think to yourself, where is that document? Is it an agreed upon document? If so, is it in your document, your joint document book? If it's not an agreed upon document, do you have the ability to prove that document? Are you missing documents? If you're missing documents, then you've got to get them now. So you're going to get them either from your client or your witnesses. And if not, you need to ask the other side to get them. Do that formally. Make sure you've got a formal request to get the documents that you need to prove your position on each point. After you've got your documents in order, again, for each issue that's in dispute, think about which witnesses do you need to call to show your position on that point. And you're going to start with, do you need experts? And if so, you've got expert reports. Do you really understand what your expert is going to be saying? This is a good time to call your expert and discuss their evidence with them. And be careful, because your expert is going to say, if properly questioned, what they know in the whole area that they have expertise on. So discuss with your expert not only the strengths and what you want to come out, but also the weaknesses of what the expert is going to testify about. Think about your other witnesses as well. Are you going to need to subpoena anybody? Is anybody not going to be available at certain dates, so that you know that before you set a date for trial? And then you've got your strategy and your organization for the issues that are in dispute. All that's left now is the issues that are admitted, but you want to make sure there's no confusion about that. The best way to do that is phone your opponent and say, here's the issues that I think are resolved. Do you agree? And if they agree, confirm it in writing so there can't be any confusion later, because people forget, there's different lawyers, whatever the situation might be. It's also a good time when you're doing this with opposing counsel to sweep up loose ends or tidy up small details. For example, you may be able to swap admissions. When you're trying to do your net family property statement and you've got, as Melanie was indicating, the problems about the furniture, or you may have problems about what did people have and what was it worth on the date of marriage, you may not have documents about that, but the witnesses and the clients tend to know what was going on, and maybe you can agree on that and swap admissions about it. At this point, if there are children, you probably know what the special and extraordinary expenses are. Maybe you can do a list of what they are, what they're expected to be, and perhaps agree upon what the cost of them are. Anything else that you can agree on, that this is a good time to do it. And now you've taken stock and you're all set. There's only two more things that I would do at this time. The first is review your offers to settle, because now you understand your case well, you understand the strengths and weaknesses. Look at your offer, look at the opposing counsel's offer, and this may be a good time to have settlement discussions. And last but certainly not least is make sure you discuss all of this with your client, so that your client, and not just you, is up to date, understands the strengths and weaknesses of your case. And then you've taken stock, your client's taken stock, you're ready for that settlement conference or pretrial conference, and you're all on your way to being prepared for trial. Thank you.
My topic today is family law settlement conferences. First thing I wanted to point out is that there's a terminology issue in the various jurisdictions across the province that one has to be alive to. A settlement conference in a unified family court or family court rules jurisdiction has a set definition, a specific definition. In other jurisdictions such as Toronto or other cases where the rules of civil procedure apply, there's different terminology. But just to deal first with the family law rules, case conferences, settlement conferences, and trial management conferences are all defined terms. They're all under Section 17, Sub 4, 5, and 6. I won't be dealing with trial management conferences, as I understand that's a separate topic for later in the program. But you can see the difference between a case conference and a settlement conference by comparing the definition sections, which I've set out in my paper. The ones that I think are most instructive is that in 17.4, the case conference is for the purpose of identifying the issues, of having the parties agree on a timetable. And these are obviously preliminary steps. In 17.5, to deal with the settlement conference stage, we're talking about settling or narrowing the issues in dispute, obtaining a view of how the court might decide the case. So the settlement conference is indicative of a conference that takes place at a point where you've passed the preliminary stage. In Toronto, the term case conference applies to any pre-hearing conference except the one just before the trial. In the jurisdictions where the rules of civil procedure apply, the term case conference isn't defined. However, Rule 50 on pretrials provides that a judge can order a pretrial, and it is that rule that would allow you to have a conference of a settlement, similar to a settlement conference, prior to the calling of a matter for trial. But in my submission, having a case conference or a settlement conference is one of the most potent weapons in the arsenal that family law lawyers have. If a case is starting to drag, it's all you have to do in Toronto is ask for a case conference to get the case moving, and it prods the other side into activity. Most family law cases don't go to trial, and although this program deals with how to prepare for trial, it's my thesis that since about 98% of these cases end up settling before you have a trial, it might be worth spending more effort on the pretrial conference or the settlement conference to the point where, of course, you know you're going to have to go to trial because most of the cases settle along that at some point along the way to trial. Now, I know from my experience as former CLE chair that programs such as this can't be Toronto-centric. We're always told that you can't talk about what goes on in Toronto because it's different out in the outlying areas. But Toronto has had an experience with case conferences that I think is going to be instructive and is likely to be repeated across the province. In 1998, there were 8,862 family cases issued out of Toronto. Last year, there were 11,115. That's an increase of 25%. Now, I granted that most of these, or many of these, are straightforward undefended actions, but nonetheless, the look at the trial list is also instructive. In 1998, there were 153 cases that were disposed of from the trial list. In 1999, it was down to 83. In 2000, it was down to 51, bumped up a little bit in 2001 to 59, and bumped up again to 80 last year. But the number of trials in Toronto is half what it was 4 years ago or 5 years ago, notwithstanding the fact there's been a 25% increase in the volume. And that's because of Justice Walsh's term, front-end loading the system, where the point is to get to a judge at an early stage of the action before people have dug in and taken positions that they may find difficult to get out of. But settlement conferences are the type of proceeding I'm talking about in this paper is where you've got some of the preliminary information. It's not the very first meeting with the judge. It's at a point where there's been some disclosure back and forth, and the aim is to try to meet with the judge to hopefully settle the case, but if not, move it on to trial. Now, the rules that apply to materials to be filed at a settlement conference also vary from jurisdiction to jurisdiction. But in light of the likely expansion of the family law rules, I'll deal with that area first. The case conference brief and settlement conference brief are prescribed forms under the family law rules, 17A and 17C. And the major difference between the two briefs is the requirement in a settlement conference brief for there to be an offer to settle, at least an offer to resolve the outstanding issues. In Toronto, the form looks completely different. It's Form 4 under the Toronto family law rules. In jurisdictions where the rules of civil procedure apply, there is no specific form of memorandum. Rule 50.05 makes reference to providing all documents intended to be used at the hearing, whatever that means. And Rule 69 requires filing of a new financial statement if there have been material changes or if corrections are necessary. In the family law jurisdictions, you're required to file a fresh financial statement if there have been substantial changes, or if the one in the record is over 30 days old, or if you've only got some minor changes, you can file an affidavit. But prior to a settlement conference, fresh financial information is required. In Toronto, the case conference memorandum requires the attachment of any agreements between the parties, 3 years tax returns and notices of assessment, financial statements or business statements, and if there are any material relative to the issues that have to be decided, this material should be included as well. In virtually every case, you should have a net family property statement. That I find a convenient document to use as your agenda for the settlement conference. And since everyone is looking at the same form, you can start at the top and go to the bottom, and everyone's on the same page. Where support's an issue, support printouts are, I think, mandatory. Judges are looking at this on the basis not of all of the wide variety of rules that they're supposed to apply, but particularly looking at what's left over after you give support at whatever level to the spouse who's claiming. The net disposable income calculation that comes out of a support mate calculation, I was told as recently as this morning, is the first thing that the judges look at because they know the budgets are flawed, they know the requests may be somewhat out of whack, and what they're looking at is who's going to have what left over after an order for support is made. Now, depending on the issues, you should also attach pension valuations, house valuations, business valuations. Sometimes, if it's not privileged, there could be correspondence that has passed between solicitors that might be a useful agenda, but that's somewhat dangerous given the fact that people say things in correspondence that perhaps they don't want to have said at a settlement conference. Confirmation forms are required in all the family law rules jurisdictions and in Toronto. And all too frequently, these are filed without any thought at all. The issues to be addressed, someone ticks all. The stuff that the judge is supposed to read is hardly ever filled in. And it's becoming an issue for the judges who look at these things. They do read them. And in my submission, they have to be filled out properly, showing the judge what you expect him or her to refer to, and outlining the issues that have to be addressed. It may not be all the issues, depending on your particular case. Ideally, the judge should only have had to read the brief, the package that you've given to the judge, and not have to go to any other source for information. Often the judges don't get the whole file, or there are parts of it that are hard to locate, and the brief should canvass all of the issues that you want the judge to address. Recently, Justice Jarvis made another suggestion that I throw out for you, and that is he finds it particularly helpful to have a summary of what's really going on in the case. And his suggestion is that at a case conference or a settlement conference, the parties file a 2-page memorandum that says what it is that they want to have happen at the case conference. He says he finds it quite helpful, and I recommend that to you. As far as the attendance of the parties on these proceedings, I submit that clients should always be in attendance. They can give instructions on the spot, and they will also get a chance to see what's actually going on, so you don't have to go and explain to them what happened. They were there, they saw the dynamics, and hopefully they were able to be instructed by it. The rules, however, don't necessarily support that. The family law rules provide that parties are to attend unless the court otherwise orders. That's section 17 sub 15. And for those of you who are going along and following the paper, there's an error in the section number. It's not 17.5, it's 17.15. The Toronto family rules provide that parties are to attend if directed. And the rules of civil procedure provide that a judge can order the counsel for the parties and unrepresented litigants to attend a pretrial conference, but doesn't say anything about represented litigants. So while there is the variation in the actual content of the rules, it's my view that clients should always be in attendance at settlement conferences or case conferences so they can see what's going on and give proper instructions. Now, the hearing itself, I put this proposition forward in an earlier paper, and I throw it out again to see if people want to take shots at it. But in preparing for a case conference, I think you have to ask yourself of each of the issues that you've identified, why does this case require a trial? And let that approach be the one that you take both in the materials that you file and in the actual conference itself before the judge. I think there are 4 answers. One is that the other side is being unreasonable. The other is, the second possibility is that the case is one of first impression and crushing importance. And you know, you have one of those when Phil Epstein's on the other side. So The third one is that there's doubt as to the outcome, and that the range of doubt is outside the bounds of that normal people may disagree about, so that either a case on credibility or something where the parties are very far apart. And the fourth answer is it doesn't. Either there's no doubt about the outcome, or the range of doubt is within the bounds that normal people can disagree, and compromise is a legitimate method of resolving those issues. So during the case conference, you have an opportunity to road test your case, to see how the judge responds to your position. You may find that it isn't the other side that's being totally unreasonable as far as the judge is concerned. You're a little bit off the mark as far as this particular judge is concerned, and that will inform you for the rest of your case. A brief word about confidentiality. The rules of civil procedure provide that no communication made at a hearing of this type is admissible in any subsequent proceeding, except as disclosed in a memorandum or order that might be made at that type of conference. Toronto family rules don't have a confidentiality rule, but because they reference the rules of civil procedure, it's my submission that that rule applies in Toronto, and that communications of that nature are privileged in Toronto as well. There's a reference to 1725 of the family law rules, and again, I apologize, that should be to 17 sub 23. And the family law rules specifically provide that evidence prepared for a settlement conference shall not be disclosed except in accordance with an agreement or an order. Interestingly enough, there is no similar rule for case conferences under the family law rule and family law rules. And a colleague of mine had pointed that out to indicate that there may be a bit of a dichotomy between the two forms of rules, at least under the family law rules. Lastly, a mention of costs. Family law rules jurisdictions have the express statutory provisions for the awarding of costs in certain events, and woe betide the council who runs afoul of any of those rules. If they're not prepared, if they haven't served a brief, if they haven't made disclosure, the rules haven't been followed. So preparing properly and conducting your case in the most effective manner is the way to go in all of the jurisdictions, but in particular ones governed by the family law rules. Thank you.
I'm Adriana Doyle, and I'm sorry I'm late. My flight was canceled, and I ended up on a later flight, so I thank Julie Hannaford for talking to you about the initial contact with client. So my reward is to talk about trial records. And up in Ottawa, we have had the family law rules for the last 4 years, so we've had some experience that you will be enjoying in the next few months. I guess it'll be July. And the first thing you should know about trial records is that as in your cases now using the rules of civil procedure, is the only document or book that a court will look at before your trial. So the continuing record, which you've accumulated during the process of the litigation, which, if you recall, is the red binder with all the pleadings and affidavits and motions, is not before the court. It's only the trial record as it is in the rules of civil procedure. The difference, though, is the trial record has other documents that you would normally not put into your rules of civil procedure trial record. It includes experts' reports, and of course, it has all the orders and the pleadings ahead of time. Please, one of the judges, when we had this conference last year in Ottawa, said, please provide clean copies. If your client has written no way on part of a wife's claim, then try to make sure that's whited out. He or she, the judge, will be reviewing this, and it's quite embarrassing if you see lie in all the answers. The second thing I guess I wanted to make sure that you realize is that somewhat like what Francine was talking about in terms of taking stock, the trial record, you've come to the point where you're going to be just at the trial door within 30 days because your trial record has to be filed by the applicant within 30 days. It's an opportunity again to look at the pleadings and look at the orders and whether they've been complied with. and look at the financial statements, because obviously you have to update your financial statement. The financial statement has to be 30 days or younger before the trial, and if there are changes, obviously you're going to have to do an affidavit to confirm those changes. So I see it as another opportunity to ensure that you're ready to go to the last stage of the process. Again, I invite you to look at Rule 23, which is the rule of, that deals with the trial records. And I invite you to look at tab 12, which outlines, again, some of the comments I've made today. The last thing I wanted to say just before I introduce our next speaker is that what I have found the most helpful in terms of at this stage of the proceedings is ensuring that you have your list of to-do, as you must when you have a trial, and the trial record, your expert witnesses, your business record notices, all your Evidence Act notices, your witnesses, your opening statement, all those things are on that list. And the trial record doesn't take a rocket scientist to put it together. It just takes preparation, which I think you understand by this end of the day is really the key to success if your matter ends up in the trial, is making sure you've crossed your T's and dotted your I's and put together the essential little book that a judge will be looking at before you start your trial. So I'm not sure if Eva Frank is here yet. She would be our next speaker. No, she's not here yet. I think she may just be outside. Just so you remember, this course allows you a $50 credit in your LPIC, and hence by September 15 next year, this will qualify you to obtain a reduction of your premium of $50 on your LPIC. And I'm not sure, we'll just have a minute here and wait to see if Eva Frank comes. You have to sit, I think it's about 15 minutes. Just hold on. Yes? Yes. Do you mind going up to the podium for those out of...
I just wonder about how it's bound. Is it a red cover in the Ontario Court of Justice with the same writing that we would have on a continuing record?
No, the question was whether the trial record would be read and bound similar to the continuing record, and the answer is no. It's normally a blue backing, and you have it just like the old with the Cerlocks. It is not in the format of a continuing record format.
Appears to be a little late. We've heard from her office that she's physically on her way. She was seen in the elevator. I suggest to use the time that we go to question period right now, and then she can wait and do the Law Society risk management session afterwards. So we have a couple of speakers who are still around, and I was going to ask them if they would come and sit here. Does anyone have any questions? Hope so. We will also program into the 3 remote facilities as well, but we'll do the Toronto questions first. Where do we put? Okay. Could you come down to the? Sorry. Could you come down to the microphone? Then they can hear it in Hamilton, Niagara, and Thunder Bay. Yes. How do we? Excuse me, because this is a little out of sequence, so I apologize. How do we get the microphones for these people to answer questions? Just take this one. Thank you. Go
Question
ahead.
relates to opening statements. I'm from Peterborough. We don't seem to use opening statements at trials in Peterborough. I don't know how you do it in Toronto, but when I've seen opening statements in the various courses that I've taken, and from what I can understand, if they're written out, how do you do it? Do you hand it to the judge at the beginning of the trial, or do you stand up there and read the opening statement? Or are you supposed to receive an opening statement from the other side ahead of time? Are you supposed to give them your opening statement ahead of time?
I hope you're intending to be here tomorrow, because that's one of the things that we're dealing with as well. But I'm sure somebody here would like to answer that. If not, I will. My very strong preference is for a written opening statement. It's not required, but I usually have it fully written out and quite frequently hand it to the judge as a aide memoire. i.e. remember what I said a week from now when the trial ends. Most of the judges in Toronto would require opening statements, and I actually had one trial about a year ago that was adjourned because the other side didn't do it, and the judge refused to proceed without one. They are expected under the family law rules, and I'm not familiar enough with them because we don't yet use them very much here, but they are required, and they are to be generally filed in a format that the court prescribe, although there's lots of space for you to add comments that you want to do. But tomorrow we'll be dealing with that in detail, both the preparation of one and demonstrations.
I have a quick question about dealing with a social work report from the Office of the Children's Lawyer. I realize that this is a document that goes into the trial record, but my question is this regarded as an expert witness report? Does it have to be served within the time period separately, even though the parties would have received the report previously?
As far as I know, it's filed pursuant to the Children's Law Reform Act. Isn't it filed automatically?
It's also filed with the court. I'm
meant.
just wondering, would there be any need to serve it as an expert report
I don't see why you would if it's already filed with the court pursuant to that legislation.
Is that in Section 112 of the Courts of Justice Act? And that's evidence. That's a court-ordered expert, a court-ordered report, and that's evidence. If you dispute it, you need to be familiar with the rules. If you have a dispute, I think in the family law rules, you have to file that dispute within 30 days. But there's a procedure if you want to dispute. Otherwise, it's just evidence, and they're not expected to be at trial.
And do you need to serve the trial record on the Office of the Children's Lawyer? Are they regarded as a party?
Yes.
Thank you.
So we're from the Children's Lawyer, and you don't need to serve us with the trial record. Unless you do, if you're planning to subpoena to call the social worker to testify, you would have to let our office know. But you don't need to serve us.
The speaker is not at a microphone, so I'll just repeat it for the benefit of the remote facilities. There's a lawyer here from the Office of the Children's Lawyer. She said she does not need to be served with the trial record unless you're intending to call the children's lawyer to give evidence. Is that correct? Do you want to come down and
Lawyer says you have to. Sorry? The order appointing the children's lawyer says you have to.
So Hamilton, Niagara, and Thunder Bay, she's coming down to tell us.
I just wanted to clarify that that's only in the case of a Section 112, where a social, now they're called a children's lawyer report, has been prepared. It's not in the case where counsel is acting for the child under Section 89. In that case, yes, you would have to serve counsel with the trial record.
Thank you very much.
If you wish to call the social worker to give evidence, do you have to serve the trial record?
The question is, if you wish to serve the social worker to give evidence, do you have to serve them with the trial record?
No.
And the answer is no. Any other questions in Toronto? Perhaps we can go to Hamilton. Hello, Hamilton. Any questions for us? No. No questions? All right. No. Niagara? Hello. Niagara, any questions?
No.
No, thank you. And Thunder Bay? There are no questions from Thunder Bay. And thank you. If there are no other questions here, and I realize a lot of these issues are simply procedural, so they don't lead to a lot of questions, I thought there may not be, or there would be few, if any. Tomorrow, I hope you'll all be present because we are doing the demonstrations and such things at that time. And now we'll proceed with Eva Frank from the, speaking on behalf of the Law Society. Is that right, Eva? Sure. She's going to tell us about risk management.
First thing I should say about risk management is always try to get somewhere before you think you should be there because they may want to start early. The next thing that I should say is that the last time I spoke to family law lawyers about the challenges you face in avoiding becoming a law pro statistic, I was approached as I was leaving by a lawyer who said that she wanted to thank me, and I thought, oh, isn't this nice, until she told me what it was that she wanted to thank me for, and that was for having solidified her resolve to get out of the practice entirely. That was not my intention then, nor is it my intention now to discourage you from practicing in the field. Rather, I'm here, whether on behalf of the Law Society or whomever, perhaps Law Pro, I'm here to refocus your attention on how to make yourselves less vulnerable to claims and how to protect yourself from those claims that they may materialize in spite of your best efforts. First, a word about me. I do not practice family law. I have never had a family law file. Why is she up here talking to us, you say to yourself. I do act for lawyers who have been sued, family law lawyers who have been sued by their clients. As a result, I more than appreciate the challenges that you face, and I have a particular awareness and sensitivity to the vulnerabilities that you have. Of course, it just isn't family law lawyers who have to be concerned about claims. We all do. But while the number of claims overall is dropping, the claims against family law lawyers is increasing. They're increasing. And the size of the claims against lawyers are increasing dramatically. Whereas in family law, 8 to 10 years ago, it was almost unheard of to have a claim with a value in excess of $1 million. Today, it's quite commonplace. Why is the family law experience so different from other areas of practice? It's not hard to understand. First, you start with the fact that you're dealing with clients who are, to varying degrees, one or all of angry, depressed, demoralized, anxious, in other words, not at their best in terms of being able to think clearly, make decisions, and behave reliably. Yet these are the people from whom you have to obtain instructions. Add to that the fact that in addition to the complexities of what is narrowly defined as family law, you are required to consider trust issues, tax issues, estate issues, and on it goes. It isn't a wonder, therefore, that whereas errors of law account for less than 7% of claims across the board, they account for 20% of claims made against family law lawyers. The unfortunate reality is it doesn't matter how skilled or careful a lawyer you are, you can't entirely protect yourself from being sued. That point was brought home very clearly to me and the poor lawyer who was the victim of this last week. She was faced with a $20 million claim. The person bringing the claim was the spouse of her client, a client whom she had represented very effectively through a lengthy trial, a successful trial, and at which she was awarded $200,000 in costs. The spouse's reaction to this was to appeal the decision and to sue the lawyer. I'm confident, I'm assuming, that we'll be successful in setting aside that statement of claim on the basis of not disclosing any cause of action. You should know, if you don't already, that if you are sued, you are in very good company. It's important that you keep an action against you in perspective. While you can learn from it, you must not allow it to devastate or overwhelm you. I've been defending family law lawyers for many years. I have never defended an action that was a result of lack of professionalism or incompetence. Mistakes happen, and clients turn on you, recasting the most competent and committed effort as negligent. It's just part of the practice of law, and all that much more so in family law. While it can't be prevented, vulnerabilities to claim can be reduced. Today I'm going to focus on just 2 areas of vulnerability reduction. They're documenting your file and managing the client relationship. I'm assuming that you've been told endless times, in countless ways, paper your file. And I expect that while you all know that it's important to do that, in practice, the need to do so runs up against the practicalities of daily practice. In truth, one of the most frustrating aspects of practicing law is the fact that we've got to protect ourselves from our clients by papering our files. It takes time, it takes energy. Clients don't want to pay us to be sending confirming letters, and the letters have to be thoughtful and thorough, because if you don't put something into them, the assumption is going to be that whatever that was wasn't discussed or the instructions weren't obtained. But it's all the more important in family law to confirm in writing, given the emotional state of your client and the very personal nature of the issues. There's another reason that is very compelling or very critical for you to confirm in writing in family law. The fact is that clients may have very different perspectives on matters, say, 2 or 3 years after they settled and they provided you with instructions to settle. A client can be in a new relationship, as a result of which he resents having to pay the spousal support payments he had agreed to, or things may not have worked out as well for a client as anticipated. The client may have forgotten her determination to bring an action to the close, even if that meant compromising her entitlement. So here's the scenario. The client tells you he wants to settle. He wants you to get the best deal you can without litigating, and has good reasons for taking that approach. You act in accordance with the client's instructions, you get the case settled. Time passes. Your client chats with friends who talk about settlements that they achieved, or your client's life hasn't unfolded as he had anticipated. He starts to question why he didn't do better in his settlement. Of course, it was because his lawyer was negligent. The resulting claim is based on the allegation that while it is true that the client said that he wanted to settle, that was only because he had not been told what his entitlement actually was, and had he been told that, he would have decided to go through and litigate. I think that somewhere on the internet there must be a template for that pleading, because I have seen it so many times in different variations. Those cases are virtually impossible to defend, where there's nothing in writing confirming the lawyer's evidence that the client's legal entitlement was explained to the client, that the client was advised that what would be involved in litigating the action and what the likely outcome at trial would be. So when you sit at your desk thinking that you don't have the time to record your discussions with your client, to confirm the advice you gave and the instructions you received, remind yourself of the potential cost to you in time of defending an action. The cost to you of having a payment made on your behalf. It's your deductible, and it's 5 years of increased levy. And think of the potential cost to you of having left yourself vulnerable to a finding of credibility by a judge against you. A lawyer's reputation is in the hands of the judge, who will determine what evidence is accepted, yours or your client's. And as I think you know, the position that so often wins the day for the client on the question of whose recall of an event is better is the lawyer. For the lawyer, the event in issue is one of hundreds of similar events over the lawyer's career. But for the client, it's the one and only such event. The judge looks at that and finds credibility in favor of the client, unless it's an extraordinarily poor witness, the client. As an aside, the recent decision of Turi and Swanwick, decision of Justice Spiegel upheld by the Court of Appeal, does not improve the situation for lawyers. That claim arose out of a retainer with respect to a commercial matter. A client came to a lawyer, said, "I'd like to incorporate a company so that I personally won't be responsible for any debts of my company." The client had retained the lawyer, the company was incorporated, the business didn't do well. The client was sued by a supplier for monies owing. The client had entered into the agreement using his own name, which was part of the corporate name, but not the corporate name in full. And so it was he who was sued. The client then sued the lawyer in negligence on the basis of the lawyer having failed to advise the client of the consequences of not using the precise corporate name, which did include the client's name. The trial judge held that while the lawyer did advise the client of the need to use the corporate name, the lawyer had produced a note on his file evidencing a discussion regarding that, and that the lawyer may well have advised the client of the consequences of failing to do so, that wasn't enough. As the lawyer knew the purpose of the incorporation was to avoid personal liability, and knew that the client was the sort who was likely to be sloppy in his paperwork, and knew that the client might not follow advice, the lawyer should have confirmed to the client in writing the advice given regarding the use of the corporate name and the consequences of not following that advice. What's significant from your perspective about this case is the judge's characterization of the client as high risk. I suspect that it's accurate to say that almost every family law client is high risk by that definition. So today, it's even more important to confirm advice in writing than it was when I demoralized the group a couple of years ago. If we're talking about papering the file, I should really start with the retainer agreement. It should be detailed. If you understand there to be any limitation on the retainer, it must be confirmed in writing, preferably in the agreement. In the absence of that, it is extremely difficult, if not impossible, to successfully defend a claim on the basis of limited retainer. Here's how the claim happens. A client consults you and retains you to bring a motion to extend the time for appealing an order, and if successful, appeal that order. It's not confirmed in the retainer or by way of letter. The monetary retainer that you get is consistent in size with the scope of the retainer. Within a few days, the lawyer gets a letter from the client confirming that the lawyer would be bringing the motion and as well would be dealing with access and custody and the divorce proceedings. Lawyer immediately, appropriately, calls the client and confirms with the client that no, it's only the motion and potentially the appeal. Months later, the client writes to the lawyer inquiring about the status of the divorce and the custody application. It's only at that point that the lawyer first puts in writing his understanding of the retainer. The client's upset. He eventually finds another lawyer and sues. But by this time, the client had been noted in default in the divorce action, and a custody order had issued in favor of his wife. The action had to be settled. Of course, your retainer sets out your hourly rate, but that may not be enough. If you're not prepared to act for the client unless your fees are paid, they're kept current, your retainer agreement must say so. If you're not prepared to fund the litigation, that must be set out clearly. The corollary to that is if the client breaches the agreement, act quickly, or you will either be deemed to have acquiesced to a change in the terms of the agreement, or you may be precluded from ending the retainer depending on the stage of the proceedings at which you seek to get off the record. Speaking of getting off the record, you can't forget that your obligations to the client continue until the order you obtained has been served on your client, the opposing lawyer, and has been filed with the court together with proof of service. That means that you've got to respond to that motion brought by opposing counsel after you've gotten off the record, but before the other requirements of the rule have been met. I was involved in the defense of an action arising out of a lawyer's failure to attend a motion in exactly those circumstances that went on for years and years. So the next time you ask yourself whether it really is necessary for you to take the time to confirm something in writing to your client, you should know that if you decide not to send the letter, you could be condemning yourself to becoming the client in the defense of an action. And as for notes, it's not negligent not to make notes. But without those notes, you're a target. Managing the client relationship. Much of what I've said up until now could fit under this category as well. The need to manage and maintain a client relationship affects how you approach every aspect of the retainer. It's critical from the outset, but like so much else, it isn't easy. You have your first meeting with the potential client. It's clear to you right away that this person has unrealistic expectations. But your concern is that if you tell him that he can't expect such a result, he'll just pick himself up and go find another lawyer. So, do you gamble on being able to moderate his expectations as time goes by and he gains confidence in you, or do you lose the client? Based on what I've seen, I can tell you that a client with unrealistic expectations is a client that will inevitably be dissatisfied with what happens. And a dissatisfied client is one you don't want to have for any number of reasons. Sometimes we as lawyers are responsible for unrealistic expectations. Take, for example, the following situation. And all of these examples are real cases. At your initial meeting with the potential client, based on the information provided to you, you conclude that the client is entitled to very substantial support, and you tell her that. You also conclude that you can probably effect a quick settlement. So you tell her that, but you assure her that if that's not the case, you will fight to the bitter end if that's necessary. Based on that, you're retained. 1 year later, after complex litigation, extensive negotiations, you recommend to your client that she accept her husband's offer, which is a tiny fraction of what you had said that she could expect to receive. Your client is angry at the offer, frustrated by the delay, and really upset by the size of the account that she's received from you. What's the next step? She begins to question whether she has received competent advice and representation, and she goes looking for a lawyer, another lawyer, who will confirm her suspicions. How do you avoid or control this? First, that lawyer should have done a better job at managing the client's expectations. This means assessing the client's case realistically and on an ongoing basis, and conveying those assessments to the client. It's critical, if you are to limit your exposure to a claim, that you communicate not only the upsides, but also the downsides of the case. If your initial assessment changes, tell your client, along with the reasons for the change. And as for the cost of the litigation, you have to be realistic in your assessment and upfront with your client. And if the expectations as to the cost prove to be wrong, let your client know as the action proceeds. Don't wait until you have a huge account to render to explain why the costs are many times over what you had predicted. Fee disputes are the cause of a significant portion of negligence claims, not just in family law. I've recently seen a family law case in which a client who received extraordinary service from her lawyer over a period of number of years, an unbelievable number of court appearances, with an excellent outcome, turned on that lawyer when he demanded payment of a final outstanding account. Before he could take any action against her, she sued him. The problem the lawyer faced, apart from the enormous trauma of this happening, was that to defend it would involve an enormous commitment of time. There were almost 40 bankers' boxes of documents in this file. The time, of course, is unpaid. And the fact that when all of those documents were put under the judicial magnifying glass and filtered through the lens of what is sometimes unrealistic high standards applied by judges, it could not be guaranteed that there will not be something that a sympathetic judge to the client could use as the basis for making some finding in favor of the client. So the bottom line, keep your accounts to your clients current and think very carefully about pursuing a client for fees. Make sure you've done the analysis and concluded that the potential upside justifies the risk. Here's some more tips for client management, just quickly. Discuss strategy with your client and the risks associated with the different approaches, and then confirm those discussions in writing. The most careful, prudent exercise of judgment leading to a course of action will not protect you from being sued if there's no documentary evidence of the analysis having been undertaken and then the course of action having been agreed to by the client. Let the client know the limits of your expertise. Your client must be told, in writing, of the need to obtain expert advice, whether it's with respect to For example, valuing a pension or determining the tax consequences of the transfer of an interest in a private company. Finally, trust your instincts. I have heard so many times, I knew the first time I met with this client that he'd be trouble, but I thought I could manage him. The fact that I became involved in the file proves that the first instinct should have been followed. I want to throw out just a few perhaps obvious reminders before ending that might perhaps save one of you from the unpleasant experience of becoming a client in my office. Don't act on both sides of a domestic contract. No matter how friendly and cooperative the spouses to be appear, no matter how insistent they are, just don't do it. They are adverse in interest. The risk to you cannot be justified. Be careful with ILA. The standard for ILA in family law is different from other areas of practice. It isn't enough to ensure that the client understands the significance and meaning of the document that you've been asked to review. You have to go further. You have to provide advice as to the reasonableness of the document from your client's perspective. That means that you need to review the underlying documentation. Do not agree to provide ILA to a client who insists that that is not required. Do take advantage of checklists, Practice Pro, case management software. Do not give up the practice as a result of demoralization. Know the risks and protect yourself as best you can. And then, my apologies to Law Pro, if the worst happens and you are sued, you've got insurance. It's not the end of the world. Thank you.
Thank you. We have finished for today. Please complete the evaluations, and we hope to see you all tomorrow for the demonstrations. Thank you.